Oh, this is exciting. Welcome to the Armchair Attorney Podcast. I'm your host, Matthew Leffler, the Armchair Attorney. Are you excited? Are you excited? I am very excited. So, look, there is so much we have to catch up on. There's been a lot of stuff in the news. We'll talk about that. Look, there's only so many cases that happen in your lifetime. They go like, that's really interesting. Let's learn about this case. And there are two cases we're going to talk about today and the resolution of those cases. We're going to talk about defamation per se. We're going to talk about non-competition agreements. This is like the greatest hits. We're watching big competitors that fight viciously in the marketplace of ideas, but also fight viciously in the American legal system. Oh, this is exciting. I'm streaming this live to all these different places. We've done no promotion. We just did a couple posts on Twitter about this, or X as they insist that I call it. Still the Sears Tower for me. I'm not going to call it the Willis Tower. You call it whatever you like. Let's talk about it. Now, look, there are visibility platforms. These visibility platforms are basically consuming information from ELDs. So a couple years ago, as you might remember, the FMCSA made a mandate that said every motor carrier has to have an electronic logging device. This is how they would track, make sure your hours of service are in compliance. The goal was to provide more safety. That's debatable. I think it's even fair to say that it probably didn't increase safety, but it did reduce hours of service violations. So that's a win. But when you have this ELD mandate, an entire industry came into being. This industry of tracking information about motor carriers and truckers and drivers, and how do you aggregate this data? So before I can talk about Project 44 and FourKites, I have to talk about telematics, connected systems. Oh, we're talking technology before we talk about law. That's right. So when you have an ELD mandate, the government forces you to buy a subscription service. These subscription services are these electronic logging devices, hours of service, compliance, all of this. And what happens is the FMCSA says, look, we're not going to be the ones to tell you what device is good. We're not going to tell you what device to buy. We're going to say, let the manufacturer of the device certify that it meets these requirements that we have under our regulations. It's called self-certification. As of today, there's about 1,000 devices that have been self-certified by the FMCSA that are able to do ELDs. About 200 of those have been revoked, but that's a story for a different day. So you have hundreds, thousands of devices pushing data to whoever needs to see it, to the manufacturer of the device, to the motor carrier, all of this. Well, there had to be some way to aggregate that, to build the piping of the connected ecosystem of moving freight. That's what gave rise to companies like FourKites and like Project 44, lowercase p. It's noted in the Illinois Supreme Court. Now, these companies raised enormous amounts of money, and they competed head to head for getting the opportunity to sell their services to brokers, to talk to shippers, and ultimately to consume data from the motor carriers. The integrations is what really is so fascinating. But it's never that easy. Coke and Pepsi, which one do you prefer? That's what happened with Project 44 and FourKites. Now, there was a statement released yesterday. I'm going to read the statement, and as I read it, I hope you can follow along. Let's cue it up. There it is. Business Wire. Oh, yes, the Business Wire. FourKites resolves legal disputes with Project 44. And let's go from the top. Chicago Business Wire, December 2nd, 2024, 10 a.m. Eastern Standard Time, about 24 hours ago. FourKites today announced that it had resolved 2 legal disputes with Project 44. The first involved a complaint by FourKites over Project 44's hiring of 2 FourKites employees. Let's stop there for a second. What do you think that is about? It's about non-competition agreements. This is why I'll be very clear. I have not represented either party. I do not represent FourKites. I don't represent Project 44. They've never come to ask me for advice. If they did, I would probably give them different advice than what ultimately was what happened. The first case is about non-competition agreements. Non-competition agreements. You know, the things that I talk about all the time, the things that 30 million working Americans are bound by. Again, 1 in 5 or so working Americans have a non-compete. Well, what happened in that first case that FourKites talked about in this press release was two of their, let's call them middle managers, implementation managers, whatever. They left working for FourKites and they got new jobs at Project 44. You work at one place, you could probably work at the other place, unless, of course, you have a non-competition agreement. And immediately when FourKites learns of Project 44 hiring two people, they sue them in Illinois Cook County to say you shouldn't be allowed to work there. You signed a non-competition agreement. And they sued Project 44. And what do you sue the new hiring entity? You sue them for tortious interference, tortious, twisting, interference with the contract. FourKites had a contract with their former workers that said you can't go do the thing that you've been trained to do for a competitor. And so they sued. And that litigation, as of yesterday, apparently is resolved. But again, FourKites sues their former colleagues because they're, I don't know, terrified that the people that are middle managers can destroy their business. I have no idea. Every argument I've ever heard in favor of non-competes, except for the sale of a business and a few other interesting nuances, they don't make any sense. So it's great to see that FourKites has settled that with Project 44. Let's continue on the press release. Back it up. Oh, there it is. The second involved an older complaint by Project 44 regarding two emails sent 5 years ago by FourKites founder and CEO, Matthew Ellenjickle. Is that it? Ellenjickle? Correct me if I pronounce it wrong. Ellenjickle? To 3 individuals associated with Project 44. 3 individuals. This is the case that was so captivating. So again, the way it's described in this press release is an older complaint by Project 44 regarding 2 emails sent 5 years ago by the founder and CEO of FourKites to 3 individuals. Golly gee. Who were those individuals and what were in those emails? There's stuff in the post that I made earlier, both on, I think, Twitter and Reddit and also on LinkedIn, that kind of talks about what was said. I'm not going to repeat it here because I think that's probably not a good idea. But essentially, what was communicated was that Project 44 was a criminal enterprise. There was other bad things that were happening. And these statements were sent to board members of Project 44. And I believe the chief revenue officer, the chief financial officer of Project 44. What? Are you serious? Like, that was what this was about? They're admitting in this thing. Let me pull this up again. 2 emails that were sent by the CEO and founder of FourKites. Now, this case captivated me because I am an Illinois licensed attorney. I like to follow the law in the state of Illinois. It's good to know what's happening. And this case became one of the most important, and I mean important, defamation cases in the state of Illinois, and probably one of the most important defamation cases in the entirety of the United States. If you read through the documents, and I did that, you don't have to, you see the argument that's advanced. At its core, FourKites said we may have said those things, but we don't believe we caused any actual tort. We didn't do anything wrong, because their belief, incorrect belief, I'll say, was that the board members and the C-suite, the senior leaders of Project 44, were the exact same thing as the entity itself. So when you talk about defamation, it is an intentional tort. If you say it, it's slander. If you write it, it's libel. And it's about an untruthful statement that is published, which is the word we'll talk about in a moment, which is published, and then it is something that causes damages. Now, a lie is something you can prove or disprove. You can say, here's the evidence, and this is true or not. Publication is telling a third party, telling somebody who's not the person you're talking about. So it's not like, hey, I think you're this. It's not that. It's, I think that person is this. That is when you have publication, whether it's published by speaking or published by writing. And the argument that went up to the Illinois Supreme Court, which was decided back in March of this year, was that publication was not met, because the people from FourKites, again, let's bring this up. Let me read this right. 2 emails that were sent by the CEO and founder to 3 people at Project 44. Let's keep that in mind. Okay. Those 3 people that were sent these emails, that wasn't publication, because they're the same thing as the company. That's a dumb argument. It's a very dumb argument. And they lost. And they correctly lost. That was what we had predicted would happen when it went to the Illinois Supreme Court. Well, once you have this thing that gets brought to the Illinois Supreme Court, you make case law. What is case law? Case law is the thing that you cite in the future. Your name, your party names, are forever part of that story. The defamation that takes place through publication of the emails being sent to the board members and the C-suite. That's wild. Now, that's just the beginning of this. When we first talked about this case, we were talking about the pleadings, the very beginning of all of this. This is not the final story. This is just this is what we think happened, and we're going to fight you because we don't think you actually published it. Now, people were asking, what were the damages? What are the damages of these statements that were made? And that's a really interesting question. Normally, in defamation, you have to prove that you were hurt. You have to prove that your reputation was damaged. You have to prove that you lost business. You have to prove these big things. It's an important part of it. If you can't prove damages, defamation doesn't work unless you say certain things. If you say certain things, we call them defamation per se. And I've talked about what those defamation per se aspects are in the state of Illinois. And it was clear that the statements that were done by the CEO and founder of FourKites were defamation per se. They didn't argue that they weren't defamation per se. They argued that it was about the publication. So it goes back. What happens after the Illinois Supreme Court weighs in is they say, look, this case continues. They have alleged sufficient information to go on with the next phase. So you go back to the trial court, back to the lowest court, and then you have discovery. Discovery is when you change information, you send questions, interrogatories. And as of December 2nd, 1 day ago, the people at FourKites said, okay, we are getting our clocks cleaned. They are getting destroyed. I have no idea how much either party has paid in legal fees at this point. Maybe someday we find out, but I would have to wager, and just an educated guess, hundreds of thousands, millions of dollars, perhaps. And when you settle as a defendant, because in this case, FourKites is the defendant, if you settle, you're paying something to Project 44. You're doing something, whether it's the attorney's fees or the costs or other legal battles. I don't know. Now, let's finish up with our statement. Quote, "We are glad to put these disputes behind us," said Ellen Jekyll. I hope I'm saying that name right. "Our focus has always been on bringing innovation to the market, transforming supply chains, and driving unmatched value to our customers. That will continue to be our mission." Let's look at that for a second. Innovation. Innovation. I don't know how people describe innovation. I really don't. It's a very interesting word. I do know that when you sue your former coworkers or your former employees because they signed a non-competition agreement, you are trying to stifle innovation. That's what the FTC tried to do, was to stop these things. Now they lost for a lot of reasons we talked about, but if you're going to say you believe in innovation, but you're going to continue to enforce non-competition agreements, I find that to be disingenuous, maybe inaccurate, maybe something different altogether. If you're going to have your founder and CEO send emails with a bunch of, like, there's a lot you should read about, like how they discovered that it came from FourKites. Grace Sharkey has done a phenomenal job reporting on that. There's great articles, and it's also in the documents and the actual appellate briefs and all of that. You can learn about all of those things. But to kind of try to hide and then ultimately say, "Yeah, you got me. You got me. I said those things 5 years ago. We've been litigating it for 5 years, and again, we just want to focus on the task at hand." It's because you got your hand slapped. You tried to be a little sneaky. You said, "Oh, I'm gonna ruffle some feathers. I'm not gonna go out compete you with good products and good innovation. I'm going to try to make your board members and your C-suite distrust you." That's not innovation. Maybe it is. Maybe that's how they describe innovation. Back to the text. "These are old issues, and it's time to move forward," said Sean Fallon, FourKites board member and chief strategy officer. "Supply chains are more complex than ever. FourKites will remain laser focused on delivering the highest value to our customers." Great statement. Great statement. We should focus on the problems our customers have. We really shouldn't be looking at our neighbors and saying, "Why do they have something that I don't?" We really shouldn't be being so greedy and envious of others and trying to use lies and coercion to make people do certain things. I get that. I believe that that's the right mentality. But isn't it fair to say that the best indicator for future behavior is past performance? These aren't old issues. They're not even remotely old issues. These were issues that were litigated up until yesterday. Let's just bring that back up. I want to make sure he says these are old issues. No, they are not. These are new issues. These are the existing issues. These are the choices that you made as leaders. Now, as a lawyer, my job typically is to give leaders advice. And I say, this is what you ought to do in this situation. And they take it or they leave it, because in the world of business, law is sometimes a consideration, but not always the most important thing. These are not old issues. The Illinois Supreme Court case that is now case law in the state of Illinois about defamation, specifically the publication aspect of defamation, is brand new. That's new to this state. That's new, perhaps, to a large swath of the country. And we only got there because FourKites viciously fought, and project44 viciously fought in an adversarial process to get to that point. Now, I don't know how you want to frame this. There's marketing people all around. I love marketing people. I think it's a great story because most people do not understand how American business typically works. There's, of course, the competition for hearts and minds with marketing and sales, but there's also these battles that happen privately, or at least somewhat privately, in the courtrooms of America. And this is one of those instances. It is absolutely fascinating when you step back and say, what did FourKites tell us on December 2nd, 2024 at 10:02 Eastern Standard Time? We'll read it one more time. FourKites today announced that it has resolved 2 legal disputes with Project 44. The first involved a complaint by FourKites over Project 44's hiring of 2 FourKites employees. The second involved an older complaint by Project 44 regarding 2 emails sent 5 years ago by FourKites founder and CEO Matthew Ellenjickle to 3 individuals associated with Project 44. Quote, "We are glad to put these disputes behind us," said Ellenjickle. "Our focus has always been on bringing innovation to the market, transforming supply chains and driving unmatched value to our customers. That will continue to be our mission. These are old issues, and it's time we move forward," said Sean Fallon, FourKites board member and chief strategy officer. "Supply chains are more complex than ever. FourKites will remain laser focused on delivering the highest value to our customers." Suing former coworkers for non-competition agreement violations and defaming their biggest competitor through surreptitious emails 5 years ago. These are not old issues. These are the issues we all face every day. And when leaders make the decision that they ought to do something or not something, it is interesting. My hope in all of this is to help you understand how the sausage gets made. When things happen, we usually don't hear the story ending. You see the headlines and they quietly disappear. If you read that press release yesterday, you would probably think innocuously, this is just, the same stuff we see every day. But is it? Visibility is the promise of knowing where your stuff is at any moment. The federal government mandated that every single interstate motor carrier, with some very small exceptions, have to have an electronic logging device. Those devices have spurred an enormous amount of growth in the transportation business, with providers who take that data, take those insights, and make them actionable. But it's no different than any other business. They live and breathe by EBITDA. They live and breathe by market cycles. And sometimes they do things that maybe they shouldn't have done. The best indicator for future performance is past behavior. I fundamentally believe that. And if you're tempted to sue your former coworkers because they've signed a non-competition agreement, you and I probably aren't very friendly. And that's okay, because honestly, most people dislike me, or at least they probably should. I'm grateful for the chance to talk to you today about this case. It is amazingly interesting. We will see this case in future citations of defamation cases. When you tell something to a third party, is that third party a board member, C-suite? Now we know. At least in Illinois, that is publication. These aren't old issues. They're actually new, brand new, novel issues. That is the type of innovation that we lawyers do find compelling. So thank you for joining me today. It's been a lot of fun. I hope you learned something. Look, the reality is, it's really hard to teach legal topics. They're very esoteric. They're hard to understand. And they're intentionally done that way because we use a entirely different language. They call it legalese for a reason. The goal, as always, is to bring you something that is interesting and useful and relevant, and hopefully breaks down this absolutely fascinating case. Remember, Project 44 and FourKites are coming off the tailwinds of the federal government mandating electronic logging devices. Every truck at some level is connected to everything else. Making that data available for shippers and brokers is incredibly valuable. It powers incredible tools that have helped us combat fraud and theft. But we have to also take a step back and say, what is it that's actually happening in the weeds? In the weeds, we see people being sued who have no ability to fight these cases. They have no ability to fund them or find, new jobs. That isn't something we should be excited about. And when the going gets tough and your competitor starts to beat you down in the marketplace, maybe lying to their board members with surreptitious emails might not be the best choice. Kind of makes you think, hey, who's driving this ship? Who's operating this machine? It seems a little strange to me. Well, that's it. I hope you've enjoyed this brief foray into the world of all the things with law. It's great to have you back, as always. Thank you, Alex. I'll put you up there. We have a couple comments. We'll say hi to Alex. Good dude. Thank you for tuning in. I think this is a lot of fun. If there's legal cases you find interesting and don't understand, you can send them to me, old Matthew at armchairattorney.com. That's me, the Armchair Attorney. As you know, I am powered by the floating disembodied head. Good to see you, head. As always, I appreciate your help. And until next time, we'll see you later. Actually, no, wait, hold on. One last thing I should talk about. Today. Hold on, let me stop the music. This is important. There. Okay. The most important legal case in the entire supply chain is happening right now in the state of Texas. This is the case of Werner Enterprises in a catastrophic collision that ended up with one child dead and one seriously injured. The case was about whether or not the driver and the company Werner itself were held liable. Now, the facts are as follows. It is snowing. The driver for Werner's under the posted speed limit. They never lose control. They have a truck and trailer that are mechanically sound. In the opposite lane of traffic, another vehicle is traveling. That vehicle loses control, spins out, crosses the center line, and collides head-on with the truck operated by Werner Enterprises. This case goes to trial, and at trial, it is found that the driver for that pickup truck that had the children that were injured and one who perished, they were found to be 16% at fault. The driver for Werner, in this case, was found to be 14% at fault. Now, I'm no mathematician. 16 and 14, carry the one. It's not 100. So there's a remainder of 70% liability, and that 70% was given to Werner. Werner was found liable for over $90 million. That case was appealed to the Texas Appellate Court. On appeal, they lost. Werner lost again, and the interest continued to compound. That number then became over $130 million. And December 3rd, today, that case is being argued in front of the Texas Supreme Court. They're trying to reverse the verdict that happened at trial. This case is incredibly interesting for a variety of reasons. I do not know which way this case will end up going. I hope for motor carriers everywhere that ultimately Werner is vindicated in this case, but we have no idea. I think it can go either way, though the Texas Supreme Court, I feel, is more amenable to the arguments that are being advanced by Werner and the other entities who have filed briefs in support of Werner. We will find out the answer probably in a couple of months, though it is possible that you can kind of glean through the oral arguments which side the judges may fall on, but it's anyone's game when you're up at the Supreme Court. And that is the last place this thing goes. That Werner case does not go to the Supreme Court of the United States. That is a state law issue. Will not go any further than the Texas Supreme Court. So that is a very big case we are all watching. We will continue to watch that. And then later this Friday, I have my good friend Brandon Weissman of Truck Safe Consulting, the Childress Law Firm, and E-Regs. He's got a whole bunch of really cool stuff. We're talking about broker transparency, speed regulators, autonomous trucks, all of the beautiful regulations that everyone gets so excited about. So as always, thank you for tuning in. We can put the music back up. There you go. Look at that. It's like I know what I'm doing. And I'll leave you with the statement, enjoy. Take another read of it. It's really interesting. I mean, it's absurd. That's absurd. We're going to figure out who sent it. Ridiculous. Put the disputes behind you. Put the disputes behind you by paying money, typically. Say, hey, I don't want to do this anymore. This isn't fun. Man, if I was a shareholder, I'd be asking some big questions. Big questions. Visibility, connectivity, science. Thanks for tuning in.